Chapter 6, Criminal Law and Business, presented by Kelly Herzik. Here are the key points that we are going to study in this chapter. The definition of criminal laws, the basic elements of a crime, classification of crimes, what are white-collar crimes, who bears responsibility for corporate crimes, basic criminal procedure, and laws aimed at preventing white-collar crime. What are criminal laws? Criminal laws are passed to punish an offender for causing harm to the public health, safety, or welfare. You probably recognize that phrase, public health, safety, or welfare, from our discussion in Chapter 5 on constitutional law. And that's because states use their police power to protect citizens and property in enacting criminal laws. Police power, if you recall, is an inherent power reserved to the states under the 10th Amendment to the Constitution. The vast majority of crimes in the United States are prosecuted at the state level. Unlike the states, the federal government has no inherent police power. But under Article 1, Section 8, Congress has explicit authority to enact criminal laws relating to counterfeiting, piracy, crimes in the high seas, offenses against the laws of nations, and treason. These are actually listed out in Article 1, Section 8. In addition, the Constitution grants Congress other broad powers. We've talked quite a bit about them in the previous chapter, such as the power to regulate interstate commerce. Another big source of criminal law powers in the Constitution is the Necessary and Proper Clause. This is also in Article 1, Section 8, and it allows Congress to enact criminal laws when they are reasonably related to the regulation of commerce or to one of the other constitutionally enumerated powers, like the war power or the maintenance of the military. A great example of this is the Uniform Code of Military Justice. I was a JAG officer, an Air Force lawyer, and on active duty, we were not under general federal criminal law. We were under a specialty set of laws called the Uniform Code of Military Justice. If you committed a crime in the military, this is the code that you were prosecuted under. What are the elements of a crime? There are two. The first is actus reus, which is basically wrongful behavior, guilty act in Latin. The second element is mens rea, which is a wrongful state of mind, guilty mind in Latin. Most often, to convict a defendant of a crime, the government must show that the defendant committed a prohibited act with wrongful intent. That means there must be wrongful behavior committed with a wrongful state of mind. So how do we prove a guilty act, which is the first element of a crime? To prove a guilty act, the government must prove all the non-mental elements of the offense. Criminal offenses have elements. Each step the government has to prove in order to convict. For example, to prove burglary, there must be unauthorized entry into a structure with the intent to commit a crime. Under the old common law, burglary required an unlawful entry into a person's dwelling at night with the intent to commit a felony therein. As you can see, the definition and the elements of burglary have been modernized, but they're generally the same, except that burglary no longer has to be committed under the dark of night. It can be committed any time during the day, as long as you break into someone's house to steal something, for example. In addition to proving a guilty act, the government most often has to prove that the defendant acted with a wrongful state of mind, which is the intent element. With respect to a relevant offense, there are usually 4 levels of intent. It varies widely across the states, so this is kind of a little bit of a generalization. But the highest level of intent is generally known as intentionally or purposefully, depending on what state you're in. The next level down is knowingly, and then recklessly, and then negligently, which is the lowest level of intent. I do want to point out that the required intent for criminal negligence is higher than the standard for civil negligence. Basic negligence for, say, running into someone and causing a car wreck. Criminal negligence requires a higher level of intent than civil general negligence. So a good example of intent is first-degree murder. Murder is the intentional killing of another human being without justification or excuse and with malice aforethought, which is basically premeditation. The intent element is the intentional killing. Now, not all crimes have an intent element. Some crimes are based on a concept called strict liability, meaning the wrongful behavior is enough. You don't need intent. These are usually regulatory crimes, like serving drinks to minors or selling cigarettes to minors. A company that may sell cigarettes doesn't intentionally sell to minors, but the fact that they do it is enough for them to be cited, usually criminally. How do we classify crimes? Crimes are classified in 3 general categories based on the seriousness of the offense. The highest level of offenses are called felonies. They're the most serious crimes. Examples are murder and burglary, like we just talked about on the previous slide. Felonies are generally punishable by more than 1 year in prison, all the way up to the death penalty. The middle classification is called misdemeanors. These are less serious crimes, and they're usually punishable by fines and or imprisonment for less than 1 year. A good example of that is reckless driving, simple assault, vandalism, trespass. The bottom is petty offenses. These are the minor crimes, sometimes called violations. They're punishable usually by a small fine or imprisonment for less than 6 months, like parking tickets, speeding tickets. Those are violations. What are white-collar crimes? White-collar crimes are something that you might actually see one day in your business career. White-collar crimes are nonviolent crimes that usually occur in the business context. They're called white-collar crimes because back in the day, every business person wore a suit with a white button-down shirt and a tie, thus the name white-collar crime. Fraud, bribery, extortion, embezzlement, and computer crimes are some examples of white-collar crime. White-collar crimes are increasing in our society. In fact, in the U.S., white-collar crime is one of the fastest growing crimes. Approximately 1 in 3 households in the U.S. are victims of white-collar crime, particularly computer and telemarketing crimes. White-collar crime is not victimless. I sometimes see that argument about white-collar crimes that, well, nobody really got hurt. It's just simply not true. People are defrauded out of millions, if not billions of dollars every year. A good example of that is Bernie Madoff's Ponzi scheme fraud. It was an investment scheme. He got people to invest in his company, but he stole the money. He converted the money, and then he would use investments from some people to pay dividends to other people. He would send out fraudulent statements. I mean, there were people who thought they were making millions, and they were actually losing every cent that they had. You might want to watch The Wizard of Lies. Robert De Niro plays Bernie Madoff in that film. The environment is often a victim in white-collar crimes as well. For example, improper wastewater or chemical disposal in public waterways or illegal venting of chemicals into the air. Often, unfortunately, white-collar crimes committed by employees are not reported by companies wary of adverse publicity. A lot of times they'll simply quietly fire the employee, and they may try to blackball them in the industry if they can. But even then, a lot of times they don't, and they end up in somebody else's company, and they're a problem there too. White-collar crimes can be punished in a variety of ways. White-collar crimes can be punished through incarceration, which is jail time, restitution, which is paying back a victim of white-collar crime the money that was taken from them, direct fines, which come out of the offender's pocket, community service, like giving speeches about the crime that you committed and how other people can avoid that crime, employment disqualification, meaning someone can't serve in that industry for, say, 5 years after their criminal conviction, Or house arrest, where they don't have to go to jail, but they have to stay in their house and wear the lovely ankle bracelet. Well, let's talk about some white-collar crimes. Bribery is the first white-collar crime we're going to talk about. It is the offering, giving, soliciting, or receiving of money, services, or anything of value to gain an illicit advantage, namely the purpose of influencing the judgment or conduct of a person in a position of trust. Bribery of a public official is a federal statutory crime. The purpose of the statute is to maintain government integrity. Bribing witnesses for their testimony is also covered by that same statute. An example would be to pay money to a government official in charge of government contracts to obtain a government contract for your company. Say, bribing someone for $50,000 so that you are guaranteed the award of a new contract for an airplane. Commercial bribery includes a bribe in exchange for new information or payoffs. You might bribe someone to give you advance information about stocks so that you could go in, buy the stocks, and then clean up when the information actually hits the public. Now, bribery of a foreign official under the Foreign Corrupt Practices Act, the FCPA, is also a specific form of bribery. Now, we discussed the Foreign Corrupt Practices Act in Chapter 2, so we were not going to discuss it here again, but I wanted to remind you that that is a form of bribery, and it's a statute that prohibits bribery in the foreign context. Another white-collar crime is extortion or blackmail. Extortion is an offense in which a person obtains money, property, or services from another person by wrongfully threatening or inflicting harm on that person, their property, or reputation. Now, some people confuse bribery and extortion, but they are actually two different crimes. Bribery is paying off another person to obtain a desired result, like getting a government contract, exchanging that $50,000 for the contract award. In contrast, extortion is a threat to do something to another person that that person does not want unless money is paid, services are rendered, or property is relinquished. A classic example of extortion or blackmail is demanding money in exchange for keeping damaging photos, often of a sexual nature, out of the press. Fraud is another white-collar crime. It's probably one of the broader white-collar crimes. It encompasses a lot of different activities. Fraud is an offense that involves an intentional deception that causes harm to another, most often in the form of lost money. These are the scammers. Fraud covers a variety of offenses such as forgery, false pretense, Ponzi scheme like Bernie Madoff's Ponzi scheme, credit card fraud, identity theft, securities fraud such as insider trading, telemarketing fraud, and insurance fraud. These are just some of the examples. For testing purposes, I think that if you are familiar with what's going on in Exhibit 6-1 on page 110, which gives good examples of fraud and brief definitions, I think you'll be ahead of the game. I don't expect you to know all the elements of all the different types of fraud, but I do think it would be important to at least recognize that something is a fraud. So that is why I think you ought to look at Exhibit 6.1 on page 110 for testing purposes. Embezzlement is another white-collar crime. Embezzlement is the wrongful conversion of another's funds or property by one who is in lawful possession of those funds or property. Embezzlement is usually committed by a fiduciary of some sort, like an attorney who receives settlement money on behalf of a client, but who converts that money for his or her own use instead of paying the settlement money to the client. Other examples are an investment broker who converts his client's retirement account for his own use, or an employee who steals money from corporate accounts that she has access to. People often confuse embezzlement and theft and larceny. Embezzlement is distinguished from theft or larceny because the offender in embezzlement does not have to take property from another. It's not an element of the crime. and that's because he or she is already in possession of the property. To commit theft or larceny, you actually have to go out and steal property from another person. But in embezzlement, the embezzler already has the property in their hand. Computer crimes are varied and broad. It's also one of the fastest growing crimes in the country. I frankly don't know how the FBI keeps track of all the new schemes and scams going on out there. It's amazing. Basically, computer crimes involve computers, crimes committed using a computer or against a computer. For example, computers hackers often use computers to illegally access computer systems to obtain information or money. People go in, they'll try to hack into your system and steal your account password so they can break into your checking account and drain it of money. That's a good example of a computer crime. Cyber terrorists, on the other hand, use computers to attack large networks to impact society. For example, cyber terrorists often try to attack power grids to shut down large areas of the country, like New York. If New York goes down in blackout, that causes panic and there's a lot of crimes that are committed, it's generally a bad thing. Cyber terrorists also use ransomware. Now, these are particularly enterprising cyber terrorists because they combine creating havoc with making cash. Like, for example, they will freeze an entire hospital and all of their patient files and everything unless they're paid a large sum of money to release the files. Sometimes cyber terrorists infect systems with a virus with the intent to cause havoc. Who is responsible for corporate crimes? Under modern criminal law, both individual persons and corporations, which are deemed to be legal persons, can commit crimes. Under early common law, prior to the ratification of the 14th Amendment, corporations could not commit crimes because they were not considered a natural person under the law and could not form the required criminal intent. They did not have the required mens rea. Gradually, courts began to subject corporations to criminal liability, primarily using strict liability statutes for regulatory crimes. In the modern day, corporations can now commit and be held criminally accountable for almost any crime, as a necessary mens rea for the offense can be imputed from the employee who commits the crime to the corporation. However, corporations cannot be held liable for crimes punishable by only a prison sentence. A good example of this is murder or assault. Corporations cannot be convicted of murder. Only the individual employee who commits the murder can be convicted of murder. What if a crime is committed in the business context? Any employee that actually commits a crime will be individually held liable for that crime. But what if the government also wants to charge the corporation? For the government to charge the corporation, the prosecutor must prove three things. One, that the employee was acting within the scope of his or her employment. Two, the employee was acting with the purpose of benefiting the corporation and not themselves. And three, the act is imputable to the corporation. This is the test I think you need to be aware of for testing purposes. I do want to point out that corporate executives also have criminal liability for the criminal acts of the corporation. They do that through a concept called vicarious liability, and they are vicariously liable for the crimes of employees if they direct, authorize, or partake in the wrongful act. There is also something called the responsible corporate officer doctrine. Under the responsible corporate officer doctrine, a court can assess criminal liability on a corporate officer even if the officer did not engage in, direct, or know about the crime, if the officer has responsibility for corporate criminal compliance and failed in that duty. This doctrine was articulated in United States versus Park. It is actually case 6.2 in your book on page 118. And this doctrine has been expanded upon in intervening years to hold CEOs liable for criminal conduct of the company when they should have been making sure that the company was not committing crimes. We're going to switch gears here and talk about criminal procedure. Criminal proceedings have much in common with civil proceedings in terms of basic pretrial, trial, and appellate procedure. We talked quite a bit about that in a prior lesson on civil procedure. However, there are some elements that are unique to criminal procedure. Here are the basic steps in a criminal action, and this is what you need to know for testing purposes. The steps are arrest, booking, first appearance, either an information for a misdemeanor or indictment by a grand jury for felonies, then arraignment, trial, post-trial, and appeal. Let's talk about the first step, which is arrest. You've seen it on TV 1,000 times. It's being taken into custody by a police officer or agent of the government like the FBI or the ATF. To arrest someone, normally the officer or agent needs an arrest warrant, laying out the probable cause for the arrest, and it's got to be signed by a magistrate judge. Now, they can also arrest someone based on exigent circumstances without a warrant if the officer has probable cause, but no time to obtain the warrant. Now, you've seen this a lot of times in police procedural dramas where someone is fleeing the scene of a crime and the hero or her heroine chase down the perpetrator and tackle him and arrest him on the spot. That is called exigent circumstances. That's an example where officers can arrest someone without a warrant to prevent a suspect from fleeing or to prevent further harm to persons or property. If they catch them in the act in the middle of a crime, they can arrest them on the spot. At the time of arrest, officers must inform individuals of their Miranda rights. Now, I've listed out the Miranda rights here. It's from a famous case called Miranda versus Arizona in the Supreme Court in 1966. It is the right to remain silent, the right to remain silent until consulting with an attorney, the right to an attorney before and during any questioning, the right to a court-appointed attorney if the person cannot afford an attorney, and the right to notice that any statements made can be used against them in a court of law. That's Miranda rights. The next step after arrest is booking. This is simply the procedure for which the defendant and the crime are entered into police records. It's almost always electronic these days. The next step is the first appearance. This is simply the first court of appearance, usually before a magistrate judge. It varies by state, but there's usually a certain amount or set amount of time, either in hours or a few days, that is required for first appearance from the time of arrest. At the first appearance hearing, the magistrate examines the probable cause for the arrest. It's a pretty low standard. For minor offenses, like traffic violations, if the defendant pleads guilty on the spot, they are immediately sentenced with no further trial. You pay your fine and you leave. If the defendant indicates that they are going to plead not guilty, the magistrate ensures that the defendant has an attorney or is appointed one if they can't afford one, and entertains bail motions. Bail is an amount of money that must be paid into the court if the defendant is released from custody to ensure future court appearances. If they fail to show up for trial, the bail is forfeited. The next step is the information or the indictment stage. This is the time when the case now moves into the prosecutor's hands. The prosecutor has to decide whether to prosecute the case against the defendant. The key issue is for most prosecutors is there sufficient evidence to obtain a conviction, usually beyond a reasonable doubt? The federal DOJ department has standards about when you can proceed, and most large state trial courts do as well. Prosecutors really don't like to proceed in cases where they might lose. They don't like to roll the dice. They think it's inappropriate, it wastes resources, trials are expensive, and somebody might walk. If they move forward, prosecutors seek an indictment for a grand jury for felonies in federal court. States do not have to provide a grand jury. The Constitution requires in the federal system that you get a grand jury for certain criminal offenses. Unlike most of the Bill of Rights, that particular thing did not translate to the states under the 14th Amendment. So states, even today, are not required to have a grand jury. If there is no grand jury, because it's, say, a misdemeanor, they issue an information. An information is just a summary of the probable cause and the evidence they expect, why they expect to take this to trial. That's an information, and it's used pretty much for every misdemeanor. States that don't have grand juries also use informations for felonies and misdemeanors. The next step is arraignment. After the information or the indictment, depending on which it is presented, the defendant is arraigned. This just means the defendant appears in court to formally answer the indictment or the information. At that time, they hear the pending charges against them and are informed of their right to an attorney and a trial by jury. They also enter a formal plea of guilty or not guilty to the charges. In some instances, defendants can also plead no contest, nolo contendere, and they can do that with the judge's permission. This is often used in traffic cases to avoid an admission of liability that a guilty plea would create in a subsequent civil suit. For example, suppose that you make an illegal left turn and a car runs into you and you cause an accident. You might get sued by the driver of the other car, and you're probably going to get ticketed by the police when they show up to the accident for making an illegal turn. When you go to deal with your traffic ticket, the judge is going to let you probably plead nolo so that you don't have to plead guilty, but you can still just pay your fine on your traffic ticket. This avoids an admission of liability in the civil suit you might be facing. I will tell you that nolo contendere is not used for felonies. No judge that I know of will allow a person to plead nolo to, say, murder. It's just not going to happen. They either plead guilty or not guilty. Now, the prosecutor and the defense can also engage in plea bargaining. Plea bargaining is the exchange of a guilty plea for reducing the charges, dropping some charges, or recommending a lighter sentence for the defendant. It kind of runs the gamut. Now, if there is a plea of not guilty and there's no plea bargaining and no plea bargaining agreement signed, there's a trial. If the defendant pleads not guilty and the crime is alleged to be punishable by 6 months or more prison time, the defendant has a constitutional right to a jury trial. And that constitutional right is in either federal or state court via the 14th Amendment. Criminal juries are often called petite juries, and they're either 6 or 12 citizen members who hear the evidence and render a verdict in a trial. Now, a defendant can waive a jury trial and have a judge-alone trial called a bench trial. That's where the judge becomes the fact finder. The judge is both the fact finder and he also rules on issues of law. He wears 2 hats. That doesn't happen all that often. Most cases are trial by jury, particularly for major felonies. Now let's talk about criminal trials. In criminal trials, the government has the ultimate burden of proof. Prosecutors have 2 burdens. The first is the burden of production. This means that he or she must produce sufficient evidence to prove each and every element of the offense charged. And he or she also has the burden of persuasion, meaning the prosecutor must convince the jury that the defendant committed the crime beyond a reasonable doubt. Beyond a reasonable doubt is the standard burden of proof in criminal trials. Now, after the prosecution presents their evidence, presents their case, the defendant can submit evidence to show the government did not meet its burden of proof, or they can also produce evidence of an affirmative defense. So what is an affirmative defense? An affirmative defense is a reason why, despite having committed the physical acts alleged, the defendant is excused from liability. The burden of proof for affirmative defenses varies widely state to state. Some states require the prosecutor to disprove an affirmative defense beyond a reasonable doubt, while some states shift the burden to prove an affirmative defense to the defendant. The defendants, though, usually have to prove affirmative defenses by a lower standard, usually preponderance of the evidence. Now, after the closing of evidence and arguments by the prosecutor and the defense counsel, the jury instructions are read and the jury deliberates. In most states and in most cases, a jury verdict must be unanimous in criminal cases. If not, if there's a holdout, it's called a hung jury. Now let's talk about what happens after the jury verdict is read and after the trial is over. If the jury finds a defendant not guilty, the defendant is acquitted and then released. If the jury finds the defendant guilty on any charge, then the judge sets a date for sentencing. This is very important. The government cannot appeal a not guilty verdict. In some countries in Europe, under certain circumstances, there can be an appeal of an acquittal. That doesn't happen in the United States, thanks to the U.S. constitutional protections. A defendant, on the other hand, can appeal a guilty verdict by claiming that the prejudicial error of law occurred in the original trial. Now, if there's no appeal, the defendant is sentenced. Now, during the sentencing phase, particularly in death penalty cases, mitigating factors are presented to the court. In federal court, judge uses sentencing guidelines to sentence defendants. Now, many but not all states have also moved to sentencing guidelines for sentencing criminal defendants. Now, I'd like to briefly make you aware of some laws aimed at preventing white-collar crime. The Racketeer Influenced and Corrupt Organizations Act, RICO. That is a federal law that has extended penalties for crimes committed as part of an ongoing criminal enterprise. This is most often used in large fraud cases where people in a business get together to cheat people or to commit securities fraud. They also use it to try mafia dons too. The False Claims Act. This is a federal law that allows employees to sue their employers on behalf of the federal government for fraud against the government. As a reward, the employee retains a share of the award recovered as an incentive for bringing a successful suit. There's also Sarbanes-Oxley. This is a federal law that criminalizes specific non-audit services when provided by a registered accounting firm to an auditing client. Accounting majors, you better pay attention to Sarbanes, because it also increased the penalties for several white-collar crimes and increased the time limit for discovering fraud, which is the statute of limitations. It's longer. There are some hefty prison sentences for felonies created under Sarbanes. For example, it's now a felony punished with up to 10 years imprisonment for the failure to willfully maintain proper records of audits and work papers for up to at least 5 years. Auditors have to keep those records for 5 years, and if they willfully destroy them, they can serve up to 10 years in prison for destroying them. There's also state whistleblower protection laws. 47 states have whistleblower laws protecting employees who report corporate misconduct, but they're not consistent. Some require that the employee must go to their superior to report the crime. Others say they have to go to law enforcement. There's a lot of protections. There's also protections at the federal level for whistleblowers. You've seen that recently in the news, I'm sure. So that's the end of Chapter 6, and that is the end of your lessons for the week.